It's our last lecture, very sad. It's been a lot of fun. It's also sad because there's so many hot topics having to do with criminal justice. We could do this for another 6 weeks. Okay. No problem. Well, no, I'm not committing to that right now. But, maybe eventually, because there are a bunch of other topics we could talk about in addition to the ones we have talked about. But today, I want to talk about juvenile justice. Okay, I thought it would be interesting to focus on juveniles as opposed to adults. Up until now, everything we've been talking about has pretty much been about the criminal justice system and adults. Well, how do juveniles, people who are under the age of 18, how are they affected by the criminal justice system? Do we treat them differently, and if so, how? This is a very hot topic for a number of reasons. First of all, there has been quite a bit of scientific development in the juvenile area. We now know a lot more about juveniles than we did, and what we know is something you parents probably already knew: kids are real different than adults. Okay? And that arguably should make a difference in terms of how we deal with them if they commit crime. Another reason it's very topical is that a large proportion, in fact, well over 50% of our serious and not so serious crime is committed by either juveniles or at least young adults, people under the age of 23, 24. Most of our violent crime and quite a bit of the rest of our crime is committed by people under the age of 24. So that's another reason this is a hot topic. A third reason is to talk about juvenile justice is that as a whole, society is more willing to be more lenient and more experimental with kids as opposed to adults. I guess the idea is we figure kids might not have fully formed their character yet, that they're changeable, that they're more treatable. So we're willing to give kids more of a break than we are to adults. And the reason this is relevant to the kinds of things we've been talking about for the last 5 weeks is that we can conceivably use the juvenile justice system as an experiment, as a way of trying out both different substantive and procedural aspects of the criminal justice system. There are a lot of exciting developments going on right now in terms of treatment of juveniles, including violent juveniles, that are very different than prison. In other words, there are a lot of non-prison methods of handling juvenile offenders that are being used right now. And perhaps if they're successful with juveniles, we might think about using them for adults as well. So that's another reason to talk about juvenile justice is what we learn from juvenile justice might be relevant to adult criminal justice. And the same thing goes with procedures. You know what the typical adult criminal trial is like, with the right to jury trial, the right to confrontation, the right to remain silent, all the rights we've been talking about over the last several weeks. Well, in the juvenile context, the adult procedures don't necessarily apply. And just as there's been experimenting with the dispositions in juvenile cases, there's been experimenting with the procedures that are used in juvenile cases. And it's conceivable that these different kinds of procedures used in juvenile cases might be more fair, might produce more accurate results, and if so, perhaps we might want to think about moving them to the adult process as well. So we're not just going to talk about the juvenile process today. We're going to talk about the extent to which the juvenile process, what's going on there, might have some implications for the adult process as well. So there are lots of reasons to talk about juvenile justice. My guess is that's all, knowing what usually has happened in these lectures, that's all we'll be able to talk about. But if we have time toward the end, we might be able to address some other issues. I think one particularly interesting hot topic, a red hot topic, is the exclusionary rule. Okay? What happens when evidence is illegally seized under the Constitution? Should it be excluded from evidence, or should it be admitted? Right now, the United States tends to exclude evidence. So if we have time, we might talk about that. And if we have more time, we'll talk about anything that you fancy. But let's talk about juveniles right now. The premise of what's going on in the juvenile justice system right now is that kids are different than adults. Of course, those of you who are parents can say, yeah, right, we knew that. We've known that for a long time. But what's new is that there's a lot of scientific evidence that supports what parents have known for quite some time. The scientific evidence is essentially of two varieties. One variety is behavioral psychological, and the other is neurological. Many of you have heard about the research on the juvenile brain, so I'm going to talk about both lines of research. I want to talk about the behavioral or psychological research first as to why juveniles might be different from adults. First of all, juveniles are much more short-term oriented than adults are. They don't think about the future much. They think about the here and now. So, for instance, in psychological tests, juveniles are much more willing to endorse this kind of sentence. I take things one day at a time and don't worry about the future. Adults are much less likely to endorse this than juveniles. If a kid wants that candy, he's going to take it. He's not going to think about punishment. He might think, oh, I might get punished, but that's off in the future. He wants that candy now. That's what he's interested in. Okay? He's not going to be worried about punishment. And along the same lines, if you tell a juvenile they might get 10 or 15 years in prison, I mean, that does make an impact. It's not as if it has no impact, but it has a very different kind of impact. Juveniles don't internalize time like adults do. 10 to 15 years scares us, right? We don't want to spend 10 to 15 years in prison. Well, it scares juveniles too, but they don't really internalize it the way we do. After all, most of them have only lived 15 years, half of which they don't remember. So it doesn't make as big a difference to them. Punishment just is not as scary to them because of their focus on the here and now. Another difference between juveniles and adults. Kids love thrills, much more so than adults. So they're much more likely to endorse this kind of statement. I like to do things that are frightening. How many times have you seen kids on their skateboards going down a stair railing and then landing on their face on the cement sidewalk? And they do it, then they get up and do it again. We would never do that, right? I hope. But that's what kids do. Extreme sports. It's all done by people under 25 years of age. All those funny home videos, people doing idiotic things and getting hurt, usually young people, right? They like thrills. They like to be reckless. It's very enjoyable to them. They're not risk averse like those of us who are mature are, okay? And that can have some very big impacts. Basically, in terms of crime. Basically, crime can be thrilling. Crime can seem very thrilling to juveniles in a way it would not seem to adults. This you all know, of course. Kids are much more impulsive. Much more impulsive than adults are. They're likely to endorse this kind of statement. I do things without thinking. How many times have you asked your children, what in the blankety blank were you thinking? And their answer is, I don't know. Or nothing. Right? They weren't thinking, literally. They just did it. They're much more impulsive than adults are. On the whole, I'm talking averages here. Obviously, there are going to be exceptions in both the juvenile area and the adult area in terms of this difference. But in terms of averages, kids are much more impulsive. So, as it turns out, juvenile crime is much more spur of the moment, much more impulsive. They do tend to commit crime without thinking. Even in other words, if they're worried about punishment in the abstract, they don't think about it when they're engaged in the crime, on average. Another difference. Juveniles are much more heavily influenced by their peers than adults are. Okay? Now, infants and kids up to about the age of 8 or 9 are focused on their parents. But once you get over that pre-adolescent stage, 10, 11, 12, and certainly 14, 15, 16, your main interest group are your friends, not your parents, for better or for worse. I know I hated it when that started happening with my kids, but that's what happens. The peers become more important than the parents. Okay? So you get juveniles endorsing this kind of statement. It's better to go along with the crowd than make people angry or disgusted with you. We all know this, right? Adolescents go with the flock. Even if they think it's a bad idea, the last thing they want to have happen is to be thought they're uncool, that they're not part of the in-group. And so, not surprisingly, kids tend to commit crimes in groups. You rarely see a kid committing a crime all by him or herself. I mean, you do, but they're much more likely to commit crimes in groups. Most gangs, average age, 16, 17, right? That's another example of this peer influence in terms of how it works out in connection with juvenile crime. Last psychological difference I want to focus on, juveniles, this is not surprising, have fewer stakes in life, right? They're likely to endorse this kind of statement, I have little to lose. Now, why is that? Well, they don't have a spouse. They don't have kids. They don't have a job. So punishment doesn't cost them anywhere near as much as it costs us. If we go to prison, our spouse, our children are left bereft, we lose our job, and that can hurt the company as well as the family because there's no money coming in from that job. None of that affects kids. None of that affects people under the age of 18. And that means that, yes, they're worried about punishment, but nowhere near as much as adults are, because it just doesn't cost as much if they go to prison, if they're detained in some way. So And one other aspect of this, which I think is interesting. Because kids don't have the usual markers of maturity, they don't have a spouse, they don't have a job, they don't have kids, what do they see as a mark of maturity? Well, interestingly enough, crime. And a lot of studies have shown that one of the ways a kid comes across as mature and knowing what's going on and being cool is having committed a crime. For better or for worse, that can happen. So there's a lot of interesting research to suggest that kids commit crime in part to become part of the group, to become a leader, and this is seen as success by some groups of juveniles. So that's the behavioral research. There's a lot of this. I could talk about this a lot more, but I think it gives you an idea of what the behavioral research shows. Then there's the neurological research. And you all have heard about this, how the juvenile brain is different than the adult brain. So we've got two different things going on. One is the limbic system. It's really at its highest stage of sensation seeking. It's raging at its highest peak at this point in time, at the point of time that a person becomes an adolescent. The limbic system is pretty active when a person is an infant as well, but not as active as it is when a person's an adolescent. Why? Because an infant, for developmental reasons, doesn't have much of a body to work with in terms of how to give into or act on sensations, where an adolescent does have a body that can act on the sensations. And plus, that's the stage at which developmentally, over history, people have started to explore their environment. So that's one reason the limbic system is at its height in the adolescent period. And then at the same time, we have this other neurological development going on, which is the development of the frontal cortex. That's the part of the brain that is often called the executive part of the brain. That's the part of the brain that is thought to control actions, where people are thought to have developed their capacity to think through things, think about whether it's good to act on an impulse or not. And it's true that infants and people under the age of 10 have a very undeveloped frontal cortex. But unfortunately, for our purposes, adolescents also do not have a very well developed frontal cortex. What's going on during the adolescent years is this process of synaptic pruning. Okay? When you're born, you have a whole bunch of synapses. You have too many. They get in the way of efficient brain processing. What's happening during adolescence is slowly but surely unnecessary synapses are being removed. But that process isn't done during adolescence. It doesn't get done until about age 25. So at the same time the limbic system is firing away, the cortex still isn't up to full speed in terms of controlling those impulses. So it's almost the worst of both worlds. You got a very active limbic system, and you have a cortex that isn't fully developed. Myelination, this other phrase that's here, basically has to do with how the brain makes transmission of neurons more efficient. It involves the coding of the neural system and makes things more efficient. That process is going on during adolescence, but it doesn't get completed until the mid-20s. So once again, we have a process designed to help control behavior that hasn't been completed at the time of adolescence. I hope you're not trying to read that there, because you probably totally ruined your eyes if you have, but I will read it for you just in case, since it's up there on the screen, you're probably curious. What it says is the prefrontal cortex, which is the part of the brain on the far right there, is called the executive brain. But it is not at peak performance until young adulthood. Okay, that's what I just said. In the meantime, the ventral striatum, which is, let's see, can I move you? Here, okay, and there's the amygdala, which I'm going to refer to in just a second. The ventral striatum, this slide says, makes teenagers extra sensitive to rewards, which is consistent with what I was talking about, while the less active amygdala region leaves them less sensitive to punishments and emotional consequences. Okay? So it's again, the worst of both worlds in terms of ensuring that a person has some control over the urges. So what's the end result of all this? Well, this is sort of a summary of what I've been saying, a very simplistic summary, but nonetheless a summary. People are most likely to prefer risk. You can see from this graph at ages 15, 16, 17. That's the peak you see there. That's when people are going to be the least risk averse, the most risk preferring. Right around that middle adolescent point in time. And yet, the frontal cortex, can you see that line? It might be a little dim. You can see it, okay. The frontal cortex doesn't catch up to all of this until age 26, 30. So when you're most reckless, your frontal cortex still is only about halfway developed. That's a bad situation if what you want to do is avoid impulsive behavior, reckless behavior. Some researchers have basically summarized the juvenile situation as the height of recklessness. Now again, this is on average. Obviously there are a lot of kids, including maybe some of yours, who weren't reckless at all when they're middle adolescents. But on average, juveniles are much more reckless than adults because of the kinds of things you see schematized on this chart. So that's how juveniles are different than adults. Yeah, question?
For centuries in the West, adults were 21. And during Vietnam, we changed it to 18.
Yeah, so the point, the comment being made is the legal definition, or the societal definition of youth as opposed to adulthood has changed over the years. And I want to talk about that right now because that gets us into how the legal system has confronted this situation about the difference between juveniles and adults. Up until 1900 or so, juveniles were treated like adults for purposes of criminal justice. Okay? If a 9-year-old committed a crime, they were punished the same way an adult was. Now that's not to say that there might not be clemency granted or that the sentencing judge might not be a little bit easier on a kid as opposed to an adult. But as a legal matter, as a formal legal matter, juveniles were not treated any differently than adults. Okay? However, when I say juveniles, I mean juveniles over the age of 14. They were not treated any differently than adults. If they were under 7, there was something called the infancy defense, which is like the insanity defense, except it has to do with kids. Okay? The infancy defense excused you if you were under age of 7. That's all you had to allege as a defendant. I'm 6 years old or younger. I should have an excuse, and the courts were granted. Of course, there weren't too many 5-year-olds committing murders, but nonetheless, if that happened to happen, there was an infancy defense. What happened about the group between 7 and 14? What the law generally held was that there was a presumption of diminished responsibility, but the prosecution could overcome that presumption. So you had a lot of 7 to 14-year-olds being convicted and punished as adults. But not always, because there was a presumption against that. Certainly, though, there were a number of pre-adolescents as well as adolescents under 14 being treated like adults. That was before 1900. Then, in 1899, we had the first so-called juvenile court, which made its appearance in Chicago. And this idea of a juvenile court spread like wildfire, so that by the 1930s, every state in the country had a separate juvenile court, focused solely on juveniles as opposed to adults. And that juvenile court approach adopted what I have up here as the rehabilitative model. Okay, the idea was that we're not going to punish kids anymore. We're going to treat them. We're going to rehabilitate them. That was the guiding premise, the motivating factor behind the separate juvenile court system. But over time, and I'll say more about this in detail in just a second, but over time, the rehabilitative model came under serious criticism. And so what we had, ultimately, is a return to a more adult retributive model. You all remember what retribution is, right? That's punishment that gives people what they deserve. And the adult retribution model moved the juvenile system much closer to the adult system in terms of how punishment should function. More recently, we have the development of what's called the diminished retribution model, which is a kid should still be punished. We're not going to say that treatment is the only goal of the juvenile justice system. They should be punished, but because of the differences between kids and adults, we're not going to punish them as much as adults. It's going to be a diminished retributive approach to kids. They're not as blameworthy, so they have, in other words, they have diminished blameworthiness. Therefore, this is called the diminished retribution model. And then most recently, there's been a suggestion that none of these approaches are really the best way to go, but rather the best approach is what could be called the preventive model. This is a model that's primarily focused on treatment, but only treatment aimed at prevention. Only treatment aimed at prevention. And this model is also different than the retributive models because punishment is de-emphasized. So we'll talk about all 4 of these in a little bit more detail. Let's talk about the rehabilitation model first. And the reason I want to do this is because all 4 models are still in play in this country in various forms. Some states have a combination of these models. Other states have decided to adopt just one of these models. So what was the rehabilitation model that influenced the creation of the original juvenile court? Well, interestingly enough, the underlying legal predicate was that juveniles are not blameworthy at all. They are innocent of crime. They are just so young, and this, we're talking not just about people under 10, but people under 15 or 16. Their youth makes them blameless. So, for instance, you have this statement from Jane Addams. Anybody remember Jane Addams? She was a major social reformer at the beginning of the 20th century. And look what she says. She was a major advocate of the rehabilitation model. She said the child is brought before the judge with no one to prosecute him and with no one to defend him. So in other words, we're not talking about an adult criminal process at all. There's no prosecution, is what she's talking about. The judge and all concerned were merely trying to find out what could be done on his behavior. The element of conflict was absolutely eliminated, and with it, all notion of punishment. Okay? And then you had one of the first juvenile court judges, Ben Lindsay, who put it a little bit more pithily, maybe not in the most politically correct way, but basically what he said, very straightforwardly, is kids are blameless. Our laws against crime were as inapplicable to children as they would be to idiots. Okay? Now again, maybe not the best comparison to make, but nonetheless, the idea is that juveniles are blameless. That's what these folks believed, the people who endorsed the rehabilitative model. Okay, this is not just a social worker saying this, and Jane Addams, it's a judge saying this. So, what was the impact of this rehabilitation model? Well, first of all, extremely wide-ranging jurisdiction. So in other words, these juvenile courts could not just try juveniles for actions that we would consider crimes, if committed by adults, but also juvenile courts had jurisdiction over what are called status offenses. That is, offenses that have to do with a person's status. So what are examples of status offenses? Truancy. You miss too many days of school, you could be in juvenile court. Chronic disobedience. You disobeyed your parents enough times, you could be in juvenile court. And my favorite, incorrigibility. I'm not sure what that means, but it allowed the juvenile court to cast a very broad net over kids. Right? This was a quote-unquote offense. Now, it wasn't called a crime, but it was an offense because of this idea, hey, we're out to treat kids, not punish them, so we can cast a very broad net. We're not going to put them into prison with adults. We're here to help them, and we want to help them in any way we can. Specifically, what we want to do is figure out whether we can make them a better person. The juvenile court was created about the same time we had a huge influx of immigrants in this country. And one of the purposes of the juvenile court system was to socialize immigrants. People coming from foreign countries, make sure they were like us. The juvenile court was seen as a vehicle for doing that. Okay? Now, it was seen as a benevolent vehicle for doing that. We're trying to treat them, we're trying to socialize them into becoming good Americans, but nonetheless, what that did is it broadened the scope of the juvenile court immensely, beyond what would be permissible in adult courts. So you have Judge Lindsay, the same judge I quoted before, saying, what we're looking at is whether the child's given to playing hooky from school, or bumming and running away, showing an entire lack of ambition, or desire to work and settle down to regular habits. Anybody have any kids like that? They'd be in juvenile court, okay? If Judge Lindsay has way. Okay, so very broad jurisdiction. And here's Judge Julian Mack, another very famous juvenile court judge. Why is it not the duty of the state, instead of asking merely whether a boy or girl has committed a special offense, to find out what he is, physically or morally? In other words, the inquiry was not just, did the kid commit an offense? What kind of kid is this? Does he have a good sense of morality or not? And if he doesn't, we need to do something about that. What specifically do we need to do about that? This is the kind of disposition that was proposed by juvenile court judges and social workers and actually existed in most states. Quote-unquote guarded sanctuaries aimed at protecting inmates from idleness, indulgence, and luxuries. Okay? These were reform schools, of which you've heard. Kids were taken out of the family environment and the neighborhood, which were all bad influences, and put into reform schools where they could be socialized into being better people. Okay, that was the idea. And so you had kids actually spending a lot of time in these reform schools. That was the rehabilitation model. Okay? And not surprisingly, it ended up being criticized by both conservatives and liberals. You can probably imagine what the criticisms were. Conservatives had a problem with the rehabilitation model because of the name and what it implied. Too lenient. They're 14, 15-year-olds out there killing people, robbing people, raping people. We're just going to rehabilitate them? We're not going to punish them? Give us a break. That was a conservative reaction. The liberal reaction was, this system's too arbitrary. Okay, if we're allowing the state to come in and remove someone from his or her home because they're a truant, because they're incorrigible, that's giving the state way too much power, way too much arbitrariness involved there in terms of allowing the judge or social workers to decide who's going to be removed from the home and who isn't, and how long they stay away from the home. So both conservatives and liberals had problems with the rehabilitation model. So what happened, as I said earlier, there was a movement towards the adult retribution model, back towards the way things were before 1900. The problem for the liberals was that movement went way too far. Okay, if you're talking about a pendulum swing from being very punitive to very treatment-oriented, this movement toward the adult retributive model, which took place in the 1950s, 1960s, 1970s, went almost all the way back to the adult retributive model, back from the rehabilitative model to the adult retributive model. So these are some examples of how that pendulum swung. First of all, transfer to adult court increased 70%. What's transfer? It's when a juvenile, a person under the age of 18, when they commit their crime, is transferred to adult court, tried as an adult, given adult punishment. Okay? And that has increased by 70% since 1979. 1 in 4 of all juveniles are now transferred to adult court. That's a huge increase over what happened under the rehabilitative model.
It sounds to me like the real problem is there's no trained infrastructure to actually treat these young.
Okay. Well, that was one of the problems, and I'm going to come back to that point, but since you raised it, I'll mention it right now as well. Yes, one of the criticisms of the rehabilitation model was it was only a rehabilitation model in name. It didn't actually have good rehabilitative resources, and even when there were resources, the rehabilitation didn't seem to work. There's a famous article by a guy named Martinson, the title of which basically said nothing works. Even when we have resources, there's nothing out there that really works in terms of treatment. Now, Martinson himself later recanted on that, and in fact, today, as I'll talk about in a little while, we have some very interesting treatments that do work. But yes, back in the 50s and 60s, there was a very strong belief, endorsed by the Supreme Court eventually, in ways I'll talk about a little bit later, that treatment didn't work. And that was another reason to reject the rehabilitative model and go back towards retribution, where we focus on whether the person deserves punishment. So one example of that was a transfer increased. Another was a number of states endorsed what's called automatic transfer. Traditionally, when transfer did occur, it was discretionary. In other words, even if a 16-year-old committed murder, they weren't automatically transferred to adult court. The judge looked at how treatable they were, how mature they were, and might keep them in juvenile court. But now 31 states have automatic transfer for a large number of crimes. It doesn't matter what kind of kid you are. If you commit murder, rape, or robbery, you're going to adult court, period. Okay? That's automatic transfer. And a number of states, again, applying this adult retribution model, require all 16 or 17-year-olds to be tried as adults. In other words, there's no opportunity to even be considered in juvenile court in some of these states if you commit your crime while you're 17, and even in some states if you commit your crime while you're 16. You automatically go to adult court in these states, even if you're only 16 or 17 when you commit the crime. That's a very robust endorsement of the adult retribution model. Some states allow transfer for kids as young as 11 and 12. So they can be tried as adults. That's basically a repudiation of the juvenile court model, the rehabilitation model that began in the 1900s. Okay, what was the rationale for this? Well, one was just mentioned, and I actually don't have it on the slide, so I'm glad you did. We just can't treat these kids. It would be nice if we could, but we don't really have the rehabilitation resources. Another rationale was juvenile crimes increasing. That was at least the thought. Turns out that was wrong, but that was the belief, that juvenile crime was on a huge upswing. In fact, there have been some little blips in terms of juvenile crime, but on the whole, juvenile crime has either flatlined or gone down over the last 3 decades. But nonetheless, the perception was it was going up. More importantly, I think, was this idea, which feeds right into the retributive kind of rationale. Juvenile offenders are criminals who happen to be young, not children who happen to be criminal. Okay? That was a sentiment by a number of people who wanted the adult retribution model. One of the big proponents of this idea, you may have heard of him, John DiIulio. He's actually had several prominent positions in government. He was famous for depicting juveniles as super predators. That was his word. Juveniles are super predators. And so at one point, in one of his books, he said, large majority of juvenile offenders are, quote, fatherless, godless, and without conscience. Basically, they're psychopaths, is what he was saying. Remember we talked about psychopaths a couple weeks ago? He's basically saying juveniles are psychopaths. So let's not even try to treat them. They're untreatable. Let's just put them away like we do adult criminals. Now, interestingly enough, 10 years later, DiIulio totally changed his tune. He actually helped organize President Obama's faith-based initiative designed to help inner-city kids. And so 10 years later, he was saying, I was wrong back then. But at the time he was saying the juveniles are fatherless, godless, and without conscience, he had a bully pulpit. A lot of people believed him, and that's what led to a lot of the kinds of things you see up on this screen. The increase in transfer, automatic transfer, and so on. His recantation came too late. Okay? So that's the adult retribution model. There was a reaction to this. And in the 80s and 90s, what we had was a retrenchment, at least a small retrenchment. Some of this retrenchment was based on the kind of research that I described earlier, especially the psychological and behavioral research that I described earlier, suggesting the kids are very different than adults. The brain research didn't come along until a bit later. But in the 1980s, we were starting to get a sense that kids were very different from adults, behaviorally, psychologically. And so we had, for instance, the American Bar Association Juvenile Justice Standards, which in 1980 made the flat statement, juveniles are less culpable than adults. They just aren't as mature as adults, and that's relevant under a retributive model to how much punishment we should impose. If we're going to be proportionate about things, what juveniles get should be below what adults get, because juveniles are just less blameworthy, less culpable than adults. But the ABA did not reject the retributive or punishment model. It did not go back to the rehabilitation model and saying treatment is the goal. It said punishment is the goal. It's just that punishment should be shorter. It should be fixed, but it should be proportionate. And for juveniles, it should be shorter than it would be for adults. So, for instance, the ABA said the maximum punishment for a juvenile, even one who commits a serious crime, should be 3 years. So that's how the ABA tried to implement this diminished retribution approach to juvenile justice. More recently, with the advent of brain research, there's been even more interest in this diminished retribution model. And so you see here an example of what's been proposed. First of all, we should continue to have adult procedures in juvenile court, because after all, we are focused on punishment. We want to make sure before we put a kid in prison, before we detain them, before we punish them, we make sure they did the crime, and that's why we need the adult procedures. But if they are convicted, we treat them differently than adults. We give them sentence discounts for their lesser blameworthiness of 10 to 20%. Some people have said there should be even deeper discounts of 30 to 40. But notice the more recent version of this does not say the maximum sentence should be 3 years. That was a little bit too lenient for the more recent advocates of the diminished retribution model. And they also wanted to, these people also want to limit transfer to the most serious offenses. And interestingly enough, the Supreme Court, which doesn't tend to pay much attention to academics, and we rarely get cited by the Supreme Court. When we do, we're very, very excited. But the Supreme Court has cited some academics who have proposed this diminished retribution model. In 3 separate cases, actually 4 separate cases, though Miller and Jackson were decided on the same day. In the Roper case, that's the case back in 2005, which held that juveniles may not be executed. Remember that case? That if a person commits a crime, even if it's a horrible, horrible murder before the age of 18, they may not be executed for it. You can give them life without parole, but you cannot execute them. Why did the court decide that? Because it bought into the diminished retribution idea. That no kid, no matter how bad the crime he or she commits, is as culpable as an adult who commits the same crime. They're less blameworthy. So you just can't give them the death penalty. A 19-year-old who commits a horrible crime, you can give them the death penalty. A 17-year-old commits the same crime, you may not give them the death penalty because they're less culpable. So that's what Roper held. In Graham, a couple of years later, the court held you also cannot give life without parole to juveniles who don't commit homicide. Or actually, more specifically, what the court said in the Graham case is you cannot give automatic life without parole to a juvenile who commits a non-homicide crime. You have to see if the kid has rehabilitative potential. And life without parole, of course, by definition, doesn't allow you to take into account the possibility the juvenile will be rehabilitated. And then in Miller and Jackson, decided just last term, the court said even kids who commit homicide cannot automatically be given life without parole. You have to give the juvenile, even the one who commits horrible murder, a chance to demonstrate he or she's been rehabilitated. So you cannot automatically give even juveniles who commit premeditated murder life without parole. And this is all based on the diminished retribution model. Yeah?
I got to visit people on death row, and there was an 18-year-old girl who committed a multiple homicide, and she's on death row.
18-year-old.
She was 18 when she committed
Well, that's the point. It's 17, sorry, it's under 18, in case that wasn't clear. Roper prohibits execution of anyone under 18. Okay, if they're 18, even if it's just 2 hours after their 18th birthday, they can be executed. That's the holding in Roper. Obviously, one of the issues about Roper is, well, how can you decide that someone who's just under 18 has diminished blameworthiness, but someone who's just over 18 doesn't? Well, but the law deals in categories all the time, right? Granted, you've got both over-inclusion and under-inclusion, but that's the way the law has to be in order to have a rule of law, in order to have a legal system. You have to deal in categories, and so the Supreme Court decided to draw the line at 18 for a lot of reasons. Society draws the line at 18 for lots of other purposes, too, in terms of voting, in terms of military service, and so on. Yes, question?
Yes, thank you. I should probably know this, but are juveniles who are sentenced sent to the same facilities as adults?
That's a good question. It depends on the state. No juvenile tried in juvenile court and convicted in juvenile court is supposed to be kept in an adult prison. Okay? By law, in most states, juveniles tried in juvenile court have to be kept in separate facilities. If instead the juveniles transferred to adult court under those transfer provisions I talked about earlier, they can be kept in adult prisons. But a lot of states say even if a kid is transferred to adult court and sentenced as an adult, you have to keep those kids separate from adults. So there at least is that differentiation. And some other states say this: if we try the juvenile as an adult, we can sentence them as a juvenile. So that's sort of a hybrid kind of model. We try them in adult court, we make that statement, you've committed an adult kind of crime, we're going to say you've committed an adult kind of crime, but nonetheless might still look at the juvenile statutes for exactly the kind of disposition we're going to impose. That's called blended sentencing, for what it's worth. So there are a lot of different, that's why I say these models are not necessarily pristine in any given state. A lot of states sort of combine these different models in terms of how they deal with juvenile offenders. Yeah, question?
These swings that you've seen over the last century, how much of the swing is based on real analytics, like recidivism rates and that kind of thing?
Yeah. So the question was, these pendulum swings, and there definitely have been some. We went from the adult retribution model to the rehabilitation model, and then back almost to where we started, and then the diminished retribution model sort of moves us sort of to the middle, more or less. And the question was, how much of that is based on criminological data, on recidivism rates among juveniles and so on? It's mostly political and not based on science. But as I said, the move back to the adult retribution model was in part based on science. That is, that the juvenile crime rate had gone up. Unfortunately, it was inaccurate science. In other words, it was pseudoscience. The claim was made that juvenile crime rates had gone up, but in fact, they hadn't. So sometimes advocates refer to science, but they're either making up the science or they're looking at bad studies. So I guess the short answer to your question is science does have some influence. But in our system, it doesn't have a whole lot of influence, because ultimately crimes are defined by state legislatures, which have a lot more on their plate than just worrying about what research shows. Yeah?
So how much is it influenced by the demographics? I mean, like where you have a big, you're using rate as the
Crime rate, right. Yeah, so the question is, certainly we know the baby boom generation had a whole bunch of kids, and so there are a lot more juveniles out there who are being reckless. And that might have affected the crime rate and therefore how the legal system responded. In fact, part of that pseudo-prediction that the juvenile crime rate was going to go up was based on exactly the analysis I just gave you. It turned out to be wrong. Certainly there were more juveniles out there who were available to commit crime, and the crime rate did go up a little bit, but it was a very small blip, and in fact, as I said before, the crime rate eventually flatlined and actually went down to some extent. And now it's definitely going down. Of course, now we have fewer kids out there, okay? Because the baby boom kids have gone through the pipeline. So again, basically you asked a similar kind of question. There's not necessarily a relationship between what research shows, criminological or otherwise, and what the legal system is doing. But that's not news, right? That's not just true in this area. It's true in a lot of areas. So I want to talk about this last model, which is the most recent development. This is sort of a hybrid model. It's basically de-emphasizing retribution, de-emphasizing this focus on blameworthiness and culpability, moving back towards the treatment model, the rehabilitation model, but only treatment that's specifically focused on preventing recidivism. Remember, the rehabilitation model was not just focused on treatment that would reduce recidivism. It was focused on making the kid a better person, socializing the kid. This new approach, as the word prevention implies, focuses solely on preventing crime, not on making the person a better person, the kid a better person. So how does all that play out? Well, first of all, it's different from the retributive models in two ways that I think are worth emphasizing. The preventive model actually might end up intervening in cases where a retributive model would not. There's some very interesting research on the children who are most likely to have lives of crime, lifelong criminal activity, as opposed to kids who are not likely to be criminals their whole life. The phrases used here are life course persistent offenders, which is what you see up on the slide, life course persistent offenders, and the opposite is adolescent limited offenders. I think the phrases describe what is underlying the theory. Life course persistent offenders are people who will commit crimes throughout their lives. They basically are criminogenic. Adult limited offenders describes the vast majority of juveniles. Because of their increased recklessness, because of their fewer stakes in life, juveniles tend to commit a lot of crime. But once they get to be 22, 23, 24, they get those stakes in life, their brain's matured, the myelination process is done, the frontal cortex is now in place, crime goes down. In other words, 20-year-olds, 21-year-olds, 22-year-olds desist naturally. You don't need to treat them at that point. The vast majority of people are just going to stop committing crime on their own. That's to be differentiated from the life course persistent offenders. Now, who are these people? They tend to start committing bad acts at ages 8, 9, and 10. Okay? The adolescent limited offenders tend to start 13, 14 when they get in gangs and things like that. And they stop at age 20. The life course persistent offenders start earlier, 8, 9, or 10. And they keep on going during adolescence, and then they keep on going after adolescence. Either their brain never fully develops, or it does fully develop, but they don't care. They're going to keep on committing crime because that's the kind of person they are, that's what they're used to. So, what might be an example of a life course persistent offender? It's the kid who at 8, 9, or 10 is a bully, or likes to torture animals, or something along those lines. Now, what would a retributive system do with the kid who bullies someone, or maybe hurts a cat? Well, there might be some punishment, but it's going to be a slap on the wrist, right? That's not a horrible, horrible crime. What would the preventive model do? It would intervene aggressively in that kind of case. Because if the person's a life course persistent offender, that's the kind of person we need to deal with, hopefully in terms of treatment as opposed to punishment, so that we can prevent that person, or try to prevent that person, from becoming a life course persistent offender. If we can nip it in the bud, if we can get at the bully or the person who likes to torture animals in the bud, ideally we can prevent them from becoming life course persistent offenders. So the preventive model would act very differently in the case of this kid who's a bully or is harming animals. Retributive system, probably slap on the wrist. Preventive model, much more aggressive intervention. On the other end of the spectrum, the preventive model might be much more lenient with a wide array of fairly serious crimes. Might be much more lenient than even the diminished retribution model, much less the adult retribution model, for even some very serious crimes. Why? There are a lot of violent offenders who aren't likely to recidivate. A lot of people who kill never kill again. A lot of people who rob actually can be successfully treated. Whereas the retributive model would say, hey, you murder someone, you rob someone, we're going to give you pretty serious punishment. Even if we keep you in the juvenile system, we're going to give you pretty serious punishment. It's going to involve detention. It's going to involve imprisonment. Preventive model says, that's not necessary if the goal is to prevent rather than punish. So what would the prevention model do for some of these violent offenders? Interesting enough, and this is where I talked earlier about how the juvenile system allows us to experiment with different techniques for dealing with crime. One of the interesting techniques that's been developed in connection with juveniles is something called multi-systemic therapy, up there on the slide. And what this involves is what the name implies. It deals with the systems which are seen as the causative factors in juvenile crime. So in other words, the reaction under a preventive model is not to put the person in prison, to punish them for what they've done, but to try to reorient the systems which are said to be the causes of crime. More specifically, what happens under multi-systemic therapy is for 4 to 6 months. The therapist deals with the juvenile in the family context, in the neighborhood context, in connection with the peers. For 4 to 6 months. It's very intense therapy. And it doesn't just involve the kid, it involves the family, it involves the peers. So it's really a multi-system kind of approach. And there are 3 things to note about this kind of multi-systemic therapy. First of all, it's in the community, within the systems that are said to cause crime. If you send a kid to prison, how are you going to deal with the causes of crime? Not very effectively. You need to deal with the cause. If they're environmental causes, you need to deal with them in the context in which the kid lives. So that's difference number 1. Difference number 2, and this is the most important one, going back to some of the questions about criminological research, this is incredibly successful. It reduces crime much more. It prevents recidivism at a much higher rate than either prison or other kinds of treatment programs that don't focus on systems. Recidivism drops by 60 to 70%. Still doesn't eliminate it. You're never going to eliminate recidivism. But it's incredibly successful at reducing recidivism. And point number 3, it's cheaper. Now, if you want to sell a preventive model to a state legislature, what are you going to do? We're going to prevent more crime at a cheaper cost. And some state legislatures, including in Florida, which we learned last night, is a relatively conservative state, but who knows? So we don't know yet, do we? But we'll find out pretty soon. Anyway, even Florida has bought into multi-systemic therapy. Not so much because Florida's knee-jerk liberal, wants to be lenient, but because it's convinced that this kind of treatment process is better at prison, at preventing recidivism, and it's cheaper. This is one of those exciting developments I mentioned before. Now, would this work in the adult context? Maybe, maybe not. Maybe it's easier to treat kids through a systems approach than it is to treat adults through a systems approach, but it's worth thinking about. Right now, though, the preventive model is primarily being applied only in the juvenile context, for the reasons I said at the very outset. We're more willing to experiment in the juvenile context. We're more willing to give kids a break than we are give adults a break. Now, and by the way, the preventive model also would get rid of transfer. There would no longer be any transfer to adult court. Why? We're not interested in punishment anymore. It's not to say punishment is totally irrelevant. Certainly we want to convict the kid of a crime. We want to do something to the kid. But we don't need to send the kid to adult court to administer that adult-level punishment. What we're interested in is prevention. And if you have a dangerous kid, and there are dangerous kids, there's no doubt about it. There are 16, 17-year-olds who are very dangerous. You detain them, but you don't need an adult system to do that. You can have a separate juvenile system to do that. So we don't need transfer anymore. Okay? So that's how the preventive model is different from the retributive model. How is it different from the rehabilitative model? Because the preventive model is very treatment-oriented. So it sounds a lot like the old rehabilitative model, but it is different in a couple of ways. First of all, there's not this assumption the kids are innocent. Remember, that was an assumption in the rehabilitative model. Preventive model convicts kids. It says you are guilty of rape, robbery, murder, whatever it is. There is a conviction. So there's not this idea that kids are innocent. Secondly, status offenses probably would not be a basis for a jurisdiction. Why? Because truancy, for instance, isn't a significant risk factor for committing crime. Incorrigibility, whatever that means, is not a significant risk factor. Now, bullying is, as I said earlier. Torturing animals is, but not a lot of the things that led to that expanded jurisdiction under the old juvenile court. And finally, as my discussion of multisystemic therapy indicated, the preventive model doesn't start with the idea we need to detain these kids in these guarded sanctuaries, these reform schools. Rather, the initial response often will be community-based treatment within the kid's system, within the kid's environment and context, as opposed to some kind of isolating detention. And interestingly enough, the Supreme Court has endorsed this kind of idea as well. In Roper and Graham, for instance, it's talked about the fact we need to make sure we investigate whether a juvenile has a potential for rehabilitation and can be prevented from committing crime again. So there is some indication in the Supreme Court's jurisprudence that this is a model the court would be willing to contemplate. Yes?
Who provides the multi-systemic therapy?
Okay. What individuals? They are therapists. They're usually psychologists. They could be social workers. They have to go through a very intensive training program themselves before they can do it. Is that the kind of thing you're asking?
Yes.
Yeah, they have to go through a very intensive training program before they can engage in this. And they basically can only have 2 or 3 clients at a time because this is very intensive therapy. So it is expensive, but prison's more expensive. That's the bottom line takeaway in terms of the cost savings. Yeah.
Do we have the infrastructure available to do this?
Okay. Right. Do we have the same kind of question you asked before, right? Is there the infrastructure? Well, it depends on whether the state's willing to put its money where its mouth is, or whatever you want to say. Because Florida's been willing.
Florida's have to be lots of psychologists, lots of psychiatrists, and so on.
Right.
Are they there?
Psychologists will come where the money is. Okay? So if the state's willing to spend the money on this, then you could have an infrastructure. Florida is implementing this, not statewide, on an experimental pilot study basis. But it's willing to pour the resources into selected counties. Other jurisdictions are going statewide with this kind of thing. There's a guy here right at Vanderbilt, Mark Lipsey. Have any of you heard of Mark Lipsey? He is instrumental in this whole movement. Okay? He is a major player in all of this. He's done a lot of the research. And if you ever want to hear an interesting discussion in detail about this kind of stuff, go hear one of his lectures about this. There are lots of problems with it. This is not, I don't want to paint this as the silver bullet that's going to solve all our problems. It won't. But it certainly is a nice alternative to socking a kid away in prison, and probably increasing the potential for recidivism, given what goes on in prisons, right? But you're right, you have to have the infrastructure. States have to commit to this. And it's sometimes hard for state legislatures to commit to something. Well, we're used to prison. You want us to keep these kids in the community? I'll never get reelected if I'm connected up with putting kids in the community, because you know what's going to happen. One or two of these violent kids are going to recidivate. And then immediately there'll be an outcry and say, oh, we got to put all these kids back in prison. Hopefully a state legislator would be strong enough to resist that, given the research, but you can see why a state legislature wouldn't. And so that's one of the problems, politically, with going this route. Yeah.
With these commercial systems of, like CCA, would they be in competition with this?
You're talking about the privatization of prison? Sure. CCA, which is that Corrections Corporation of America, that I talked about a couple of weeks ago, hates multisystemic therapy. Okay? Now, there are some private companies that do multisystemic therapy. We can privatize that, too. Okay? But CCA isn't involved in that. You specifically asked about CCA. They're not involved in that.
The buildings and the contracts and the political...
Yeah, they want that major infrastructure, because that's billions, as opposed to hundreds of thousands. Yeah.
You haven't said anything about drug crimes and illegal drugs.
So the question is, or comment is, I haven't said anything about drug crimes. I mean, that could be a whole hot topic, right? Because one thing we can talk about, it goes back to the discussion of surveillance. One reason the Supreme Court has been so hostile to the Fourth Amendment is because it's bought into the war on drugs. If we start restricting the police in terms of when they can search and seize, it'll be very hard to carry out the war on drugs. So a lot of people say the reason we have a mere facsimile of what the Fourth Amendment used to be is because of drug crimes. Another point to make is about a quarter of the people in our prisons are there because of drug possession offenses, not drug dealing offenses, but drug possession offenses. You can argue about whether that's a good or bad thing. There's lots of other things I could say, but that's such a broad question. I probably shouldn't go off on that tangent for too long. Okay, unless there's a specific kind of thing you wanted me to talk about. Okay, I mean, that would be a very good hot topic. Just say drug crimes. How do they impact the criminal justice system? What are the implications if we got rid of drug possession offenses, or at least misdemeanor drug offenses, that kind of thing? By the way, some states have, as a result of yesterday. Yes?
I was going to make a comment. I worked in the correction system for several years, and the majority of the inmates that were there were 18 to 25, and crimes were related to drugs and alcohol, either breaking into a liquor store, some kind of burglary to get money to buy drugs, or
yeah. So okay, so maybe I'll tie this in now, your question, in with that point, and connect it up with juvenile justice. Multisystemic therapy, for instance, clearly deals with substance abuse problems because, as was just pointed out, that is a major risk factor. Substance abuse is a major risk factor. If you don't deal with substance abuse, you're not going to be dealing with recidivism. So that's a very important component of any sensible treatment program for adults as well as juveniles. Okay? And multisystemic therapy does have a component that deals with that. It would be totally unreasonable not to have that component in any treatment program for any offender. I want to briefly talk about procedure in juvenile court, because I think this, again, just as multisystemic therapy in the juvenile context has perhaps some interesting implications for treatment of adult offenders, there's some interesting things going on with procedure as opposed to substance in juvenile court. So this is the way the rehabilitative model handled procedure. This is Judge Mack again. Remember that judge from the juvenile court back in the early 20th century? Seated at a desk with a child at his side, where he can on occasion put his arm around his shoulders and draw the lad to him. I love this. The judge will gain immensely in the effectiveness of his work. Basically what's going on here is Mack is saying, we don't need lawyers. We don't need juries. We definitely don't need the right to remain silent. We don't need a right of confrontation. The judge and the kid will deal with this. That's how we'll work it all out. Remember Jane Addams' comment? No prosecution, no conflict. The assumption is the kid's innocent, we're going to treat the kid, etc., etc. What happened in the 1960s? All that changed. The juvenile system was adultified, to coin a word. In the United States Supreme Court case of Galt in 1967, the court said juveniles have a right to counsel, a right to confrontation, a right to remain silent. The only right that kids don't have that adults do have is juries. Kids do not have a right to jury trial, but they got all the other rights. And in later decisions, the court made it very clear that juveniles are entitled to Miranda warnings, just like adults are. And then, in fact, in deciding whether or not a kid is coerced, when he or she makes a statement, youth should be taken into account. In other words, a 14-year-old might be more easily coerced than a 24-year-old. That was the JDB decision. And in another case, the court held that kids have the same Fourth Amendment rights as adults, except if they're in school. Why is school different? Because a school is in loco parentis, another one of those Latin phrases we lawyers like to throw around. Basically, the kid in school has fewer privacy rights because the kid assumes the risk that the school will act like a parent in the school situation and consent to a search of the kid's locker or the kid's backpack and so on. But otherwise, kids have the same Fourth Amendment rights as adults. I could spend a lot of time on all those issues, but I'm not. I just want to raise the issue of whether it's a good idea to adultify the procedures in juvenile court. And here are just some questions. I'm not going to answer them. But what is the consequence of imposing adult procedures on the juvenile system? It's interesting to note that just as an historical matter, it was right about the 1960s, right about when Galt imported the adult procedural model into the juvenile system, that we started getting the pendulum swinging back to the adult retribution model. Okay? At least in terms of timing, there was almost an exact coincidence between adult procedural model being applied to juveniles and the adult retribution model being applied to juveniles. Conceivably what was going on is, hey, now that kids have counsel, we can really sock it to them. Okay? They've got an attorney to represent them, so we don't have to worry about punishing them for a long period of time. They've got an attorney who will represent their interests. Just a thought. Another question to ask. If, in fact, prevention is the goal, not punishment, but prevention, maybe it's okay to relax procedures a little bit. And that, of course, was the predicate underlying the rehabilitative model as well. If the goal is not to put the kid away for life or for 15 years or even for 5 years, but rather to engage in multisystemic therapy, maybe all this procedural regularity and formality isn't necessary. Another question. The whole idea behind the adult procedures, the right to counsel, right of confrontation, right to remain silent, right to jury trial, is we hope it'll create a more accurate process. But is that true? Is it true that juries, as opposed to judges, arrive at more accurate outcomes? Is it true that the right to remain silent produces a more accurate outcome? If the first thing you tell an individual is you don't have to talk to us, that's going to produce a more accurate outcome as opposed to a less accurate outcome? Now, I'm not answering any of those questions. I'm just saying the juvenile system gives us a chance to experiment with those kinds of questions in a way we can't do with the adult model. But if we find out that the assumptions underlying the adult model aren't correct, then maybe we ought to rethink what happens under the adult model. And one last question. Is the formal process, the adult process, more likely to produce fair outcomes? What do I mean by fair? Not so much accurate outcomes, but outcomes that are perceived as fair by both the defendant and by society. Well, how might informal procedures be perceived as more fair than formal procedures? Think about the typical juvenile proceeding in an adult that has adult procedures. Who does all the talking? The attorney. There's a lot of research on procedural justice which suggests people don't like that. Especially kids don't like that. Even some adults don't like it, though. They want to talk. They want to explain their situation. They do want to talk to the judge. Maybe not with the judge's arm around him or her, but as Judge Mack was suggesting, but at least they want to have a conversation with the judge. Instead of having this person they barely know up there telling their story. If you have the adult model, juveniles rarely even take the stand because of the right to remain silent. Is that the way to run a railroad? And again, I'm not going to answer that question. I'm just saying the juvenile system gets us thinking about that kind of thing in a very interesting way. Okay? So this book has a lot of this kind of stuff in it. What I want to do now is either stop completely and take your questions, if there are any questions at all about juveniles, or go very briefly into the exclusionary rule. Would you like to do the latter? Yes. Okay. This is a very hot topic. If I'd had a 7th week, I would have talked about this. Why is this a very hot topic? Well, you can imagine why. We are the only country in the world that excludes evidence simply because it was illegally seized. Most countries think we're idiots when we do that. You're going to let a guilty person go free because the police didn't have a warrant or because they didn't have probable cause? Remember all this stuff when we talked about the Fourth Amendment? Now, that's not to say that other countries never exclude illegally seized evidence. If, for instance, the crime is a fairly minor crime and the privacy invasion is very serious, in other words, the police go through ransack someone's home for evidence of possession of a small amount of drugs, all without a warrant, other countries like Canada or Germany might exclude evidence in that situation. Why? Because they're balancing things. It's not a very serious crime, major privacy invasion, we'll exclude in that situation. It would say bad things about us as a country if we allowed the courts to use that kind of evidence. But a serious crime, there's never any exclusion. Unless maybe the police beat the person, but then you're going beyond illegal searches and seizures to torture and that kind of thing. That's a different scenario entirely. We in this country, on the other hand, will exclude evidence anytime it's illegally seized. So for instance, there's a case, Arizona versus Hicks, in which the cops went into an apartment because somebody had shot a gun from that apartment, and they wanted to see what the hell was going on. So they go into that apartment, and by the way, they were legitimately in the apartment. It was an emergency situation. They didn't need a warrant. The gun had just gone off. They went in that apartment to see what was going on. While the cops were in that apartment, one of the cops alertly noticed that there were 2 brand new stereo sets in this apartment. Now, this apartment was very shabby, in a very rundown area. And the cop says, 2 brand new stereo sets? What's going on here? So what does the cop do? What does he do? He moves one of the stereo sets a couple of inches and gets the serial number. And sure enough, the stereo set's stolen. Well, the cop violated the Fourth Amendment when he did that. Okay? The Supreme Court held that that was a violation of the Fourth Amendment. Why? He didn't have probable cause to believe those stereo sets were stolen when he moved the one stereo set. And you need probable cause to move a stereo set 2 inches, it turns out. Okay? So, okay, you can argue whether that's good law or bad law. You can say it's good law. The police shouldn't be able to manipulate your property unless they have good cause for doing so. But the thing I want to emphasize is the stereo sets were excluded, and they couldn't convict them of having stolen property because the police violated the Fourth Amendment. That wouldn't happen in any other country in the world. We're the only country that does that. Now, is that a good thing or a bad thing? That's what I want to talk about. Okay, is that a good thing or a bad thing? Let's talk about why it might be a bad thing first. Okay? First of all, the obvious one. Guilty people go free because of exclusion. Any of you recognize the name Cardozo, Judge Cardozo, very famous judge? He said the exclusion rule is a bad thing because a criminal goes free simply because the constable has blundered. That's a famous quote from Judge Cardozo. Notice the way he puts it. The criminal goes free because the constable has blundered. Okay? Now, of course, that creates a certain image in your mind. It's a well-meaning constable. By the way, constable, love that. We haven't had constables in 2 centuries, but he uses that word as opposed to cop. Okay? The constable's blundered, but he is trying to create an image, and he is right. A lot of times, the cops think they're abiding by the Fourth Amendment. They're acting in good faith. But there's no good faith exception to our exclusionary rule. There is, but it's a very minor one so far. Okay? So even if the cop thinks he's abiding by the Fourth Amendment, there's still exclusion. So even when it's just a blunder, as opposed to a bad faith violation of the Constitution, there's exclusion. And that, of course, makes many people irritated, including most people out of the law school that I talk to. Secondly, it doesn't work. What's the point of the exclusionary rule? To deter police, right? The idea is the cop should think in an exclusionary rule jurisdiction, what's the point of going to this house without a warrant, I won't be able to use whatever I find there. So I'm going to go get a warrant. I'm going to go get probable cause. I'm going to make sure I have probable cause before I go in that house. But the problem with that analysis is the cop's not thinking that way. What's the cop's job? To get weapons off the street, to get drugs off the street, maybe to collar a guy, put him in the clink for a little while. But bottom line, the cop doesn't really care all that much whether the guy's convicted. That's the prosecutor's job. How does a cop get rated by a supervisor? How many arrests he makes, not how many convictions he gets. The conviction rate is what the prosecutor is evaluated on. It's the prosecutor who's hurt by the exclusion rule. He's the one that can't prove his case because of the excluded evidence. And in fact, when you ask cops, see, I don't think about exclusion much. Now, if you sued me, that would be a different story. If you sued me for engaging in illegal search and seizure, I might think twice. But exclusion, a lot of times I never even find out if the evidence I illegally seized was excluded. Because that suppression hearing, where it's decided whether or not I violated the Fourth Amendment, doesn't take place for weeks or months later. And the decision might not come down until months after that. And sometimes I'm not even told what the outcome of that suppression hearing is. Another problem with the exclusionary rule is it doesn't help the people who arguably want to help the most in terms of Fourth Amendment rights. The innocent people. Remember 2 weeks ago we talked about data mining and these other general surveillance techniques that sweep in lots of innocent people along with a few guilty people? There are whole bunches of innocent people being affected by the surveillance techniques. Does the exclusion rule help them at all? Not a bit. Because the only time exclusion is triggered is when there's a prosecution. By definition, innocent people are never prosecuted. So there's no chance to use the exclusionary rule to implement the Fourth Amendment. Same thing with the DWB, that stands for driving while black. Remember that discussion we had briefly? A lot of people who are stopped for being black are innocent. Does the exclusion rule help them? No. A damages action would. If you sued the cop for stopping someone simply because they were African American, that would put a little crimp in that operation. But exclusion, the cop could care less. Because he might think, okay, if I find evidence, great. I'll at least get the drugs or the murder weapon off the street. Maybe I won't be able to convict the guy, but at least we've gotten the bad stuff off the street. And if he's innocent, nothing's going to happen to me, because the only remedy is exclusion. He's never going to be prosecuted, so I don't have to worry. Okay, so those are the arguments against exclusion. What are the arguments for exclusion? Well, one argument is, to the extent the exclusionary rule is a deterrent, it does prevent conviction of guilty people, any other alternative will too. Let's say instead of the exclusionary rule, we have a damages regime where cops can be sued. I've mentioned that alternative several times. How is that regime going to function? Well, the cop's going to be sitting there thinking, okay, I don't have probable cause, I don't have a warrant. Well, I guess I'm not going to do a search at all. Even if the guy turns out to be guilty. So, in other words, just like the exclusionary rule prevents conviction of a person we know to be guilty, a good damages action might prevent the conviction of just as many guilty people, because the cop, being fearful of being sued and having to pay money, will just not conduct a search at all. And so a guilty person will not be convicted. Okay? In other words, any remedy for Fourth Amendment violations will prevent conviction of some guilty people. Not just the exclusion rule. The difference is the exclusion rule flaunts it in our faces. Right? The exclusion rule, we know the guy is guilty. We found the evidence in his house. And nonetheless, we don't convict him. Whereas the other remedies will prevent the search in the first place. And maybe that is a difference that should make a difference. But the bottom line is, just as many guilty people will go free, arguably, even with an alternative to exclusion. The other problem with, say, a damages action is it might over-deter or under-deter. Think about it. You're a cop on the street. If the exclusion rule is the main remedy, and you're not sure if you have probable cause or not, you might do it anyway. You might conduct the search anyway. Why? Your boss will like you, because if you find weapons or drugs, we'll get that off the street. If it turns out you don't find anything, again, no big deal. You're not hurting anyway. Okay? What about in a damages regime? We don't have exclusion. We have lawsuits against the police and police departments. Now the cop's sitting in his car. He's not sure if he has probable cause. What is he going to do? He's not going to do it. He's going to keep on eating his donuts. Right? Why should he go in a situation where it's ambiguous whether he has probable cause or not, when for all his pain and efforts he could get sued, or at least his department could get sued, and his boss will get mad at him? That's the idea of over-deterrence. Damages might over-deter cops from doing actions they should be doing. It could also underdeter in this sense. What if the cop really wants to get somebody, really wants to get someone, and doesn't care how they get them? Then what will they do? In an exclusionary regime, they won't do it, because what's the point? They won't be able to use the evidence they get. In a damage regime, they might say, you know what, we're willing to pay the damages. We want this guy so badly, we're willing to intentionally violate the Fourth Amendment and fork out money to pay for that illegality. So that might be an argument against alternatives to exclusion. And to this argument that prosecutors are the only ones hurt by the exclusionary rule, the response might be, well, what happens when a prosecutor loses his case? Who's the first person he or she calls? Obviously the chief of the police department, right? Say, I am really irritated. What the hell's going on over there in the department? You've got to train your people better. And there has been some evidence of systemic effect. And finally, there's this argument that if we don't have the exclusionary rule, it's going to taint our court system. It's going to make our judges look like they're accomplices to illegality. When the courts start using illegally seized evidence, evidence obtained in violation of the Constitution, by definition, that's what we're talking about, evidence obtained in violation of the Constitution, they are, in essence, endorsing, or at least acquiescing, to what the police have done. So that's called the judicial integrity argument, or the unclean hands argument. So those are the arguments for and against. We got a couple of minutes. I'm curious what you all think, or if you have any questions about any of that. Yeah.
Question about your example. You said
Which example? The last one?
where he moved the.
Oh, the stereo set.
If he hadn't moved the stereo, would it still?
If he had not moved the stereo, it would not have been a search or seizure, but then he wouldn't have known if the stereo was stolen or not, so we get back to ground zero, okay?
And it wouldn't have been grounds as probable cause that they looked.
Okay, well that's a good point. This case came up under a strange procedural posture. The prosecution thought they'd win this case, so they conceded there was not probable cause. They said at most there was reasonable suspicion. Remember, probable cause, reasonable suspicion? Said we did have reasonable suspicion, but we didn't have probable cause. Now, had they known they were going to lose, had the prosecution known it was going to lose, it probably would not have conceded that. It probably would have said, hey, you got 2 brand new stereo sets in a total slum apartment? That gives you probable cause. I don't know if they would have won that, but that would have been the optional argument. But they decided to go for broke, and they lost. Yeah.
Juvenile court.
Back to juvenile court, okay.
Yeah, does the state, like Tennessee or any state, do they have, okay, Avery County has a juvenile court. What about a statewide system?
Every state has a statewide juvenile court system, but just like with adult court, each county has, or many counties have their own juvenile court. Obviously, in very rural counties, there might not be a juvenile court, and you have to travel a distance to get to it. But it's a statewide system. Yeah.
If the constable had seen the serial number without moving it,
You like this case, huh? The 6th case? Okay. My students always are very curious about it. By the way, this is just one example of many what I would call metaphysical Fourth Amendment decisions. Just before I answer your question, there's another case where the police went through a duffel bag and found drugs in one little pocket. It's one of those duffel bags with lots of little pockets. Found drugs in one of the little pockets in the duffel bag. And it was used against a guy named Frazier. And it was admitted because Frazier's friend, who shared the duffel bag, had consented to the search of the duffel bag. And so the prosecutor said, hey, there's consent to search the duffel bag. And Frazier said, well, wait a minute. That one pocket with the drugs, that was my pocket. I mean, the rest of the duffel bag might have been something he used, but that one little pocket, that was a pocket that only I used, so only I should be able to consent to it. Now, he lost that particular argument, but you have a lot of Fourth Amendment cases where you get very metaphysical about the argument. So go ahead.
I was just curious if the serial number had been in plain sight.
That would have made a difference, right? Now, though, if I were been a defense attorney, if it's in plain sight in the sense you got to get down and squint at it, that would be a different situation than if it's emblazoned on the stereo set and easy to see. That's what the Fourth Amendment requires you to do. And the stakes get incredibly high when this is the remedy. If instead the remedy were cop, if he acts in bad faith, has to pay $40, or the department, if the cop acts in good faith, has to pay $40, that would be a different situation. When exclusion is the remedy, it gets very high stakes very quickly. And that's one of the arguments against exclusion. Yeah, I guess I'll take one more question, then we got to stop. So, yeah. Well, 2 more questions, okay, and then we got to stop.
Well, I'm just curious how it is in other Western democracies. You said we're the only country in the world that
We're the only country in the world that has what I call a mandatory exclusion rule. You have to exclude whether it's good faith or bad faith, no matter how serious the offense is. Yes?
I mean, I'm just presuming in other Western democracies that discovery is not abused. I mean, I'm just wondering what...
No. German police do violate their analogous Fourth Amendment principles, as do the French police, especially the French police, by the way, English police, and so on. They have decided exclusion is not the right remedy. Maybe you can reprimand the cop administratively. Maybe there's a damages action. Occasionally there will be exclusion in the kinds of balancing situations I talked about. The European Court of Human Rights is specifically held under the European Convention of Human Rights. We are not going to require exclusion. We're going to leave it up to the individual countries. Okay? Yeah. As last question, and then we're going to stop.
Is there a political trend towards either increasing it or keeping it or getting rid of it?
Yeah, that's a very good question, and that's a good way to end this discussion. One reason this is a very hot topic, which I forgot to mention, is the Supreme Court looks like it's posed to get rid of it or severely limit it. Okay? A couple decisions came down just in the last couple of years. It's clear that Chief Justice Roberts hates the exclusionary rule. Scalia has always hated it, so has Thomas. So we're slowly working towards a majority that will either get rid of it entirely as a constitutional requirement or at least severely limit it. It's already been limited to some extent, and I think it will be limited even more. So, yeah, Norma?
We have decided that you are a keeper, and we want you to...
Oh, well, thank you. Okay, well, good. Well, I have very much enjoyed this. I really have enjoyed it. I hope you enjoyed it. If you did enjoy it, tell my dean, okay? If you didn't enjoy it, just keep it to yourselves. And I forgot to mention, Norma reminded me of this, all these PowerPoint slides will be on the Osher website. I'm going to give them to Norma this afternoon or tomorrow. It'll still be on the website. Thank you very much.